Welcome all. Thank you for joining us. This webinar is about permanent residency strategies while you're on a temporary visa. At the start, I just wanted to flag a few things. This is not considered legal advice. This is merely a presentation on publicly available information. I am not giving any individual advice in this instance. It's a free webinar and it's meant to be educational only. So please do not take any decisions based on this thinking that this is legal advice. So that's a disclaimer that I just wanted to give at the start. A quick introduction about myself. I'm Keith James. I am the principal at MJ Legal, and I almost exclusively practice in immigration. I'm an immigration lawyer, not an immigration agent. And I've been doing and helping a lot of migrants transition from temporary residency to permanent residency. In the circumstances, basically, what I'm hoping to do today is to give all of you a broad overview of the recent policy changes, because there have been a lot of changes in the Australian migration landscape. Then I'm going to provide some insight onto temporary residency versus permanent residency and some data available on how many temporary residents are currently in Australia and how many permanent residency spots are available. So you all know or have a good idea of how competitive the landscape is and what you need to do in order to get permanent residency. From there, I'm going to break down some pathways available depending on what type of visa you have. Some of you are on student visas at the moment. It may be your first student visa, it may be your second student visa, but some of you are on student visas at the moment. Some of you are 408 COVID visa holders. It's colloquially known as the COVID visa, but it was a 408 visa that is no longer available, but some of you are still on that visa. Then also the most popular type of visa is the subclass 485, that is the temporary graduate visa. It is the visa that you get after studying in Australia for about 2 years. And then the last one is for holders of the 482 visa, which is basically the employer-sponsored work visa as it is colloquially known. So we'll break down on how you can, what visa options are available for each of you, depending on the type of visas you have. From there, I'm going to give you some tips on planning your permanent residency and how to make strategic decisions when it comes to your permanent residency. And lastly, we're going to talk about visa refusals, because a lot of you may have now applied for student visas and are on bridging visas associated with those student visas, and there's a very high risk of refusal, particularly if you lodge them just before the 1st of July. And lastly, I'm going to talk about visa timelines and how much time do you really need to start working on your plan for permanent residency. So without wasting any more time, let's jump right into it. So first things here is the migration policy changes. Last year, the government announced a migration strategy review, where the government said that they are going to change a lot of the things when it comes to the Australian permanent residency landscape. They want to end permanently temporary visa holders. So there are a lot of individuals who have been in Australia since the late 2008, 9, 10, or even the mid to early 2010s, where they all say that they were, they are basically become permanently temporary residents. So the government has said that they want to end this practice. They want to ensure that if you are a temporary resident, you have a pathway to PR and you get that permanent residency, or they actually want you to depart Australia. So that's been the strategy, and these are some of the main changes that has taken place. So the first change that we saw is the English language changes that came about for the subclass 485 and the subclass 500 student visa. So the subclass 485 is basically now requires you to have a 6.5 overall score with a minimum of 5.5 in each band for IELTS or the PTE equivalent. Also, you need to understand that now your test must be within the last 12 months. So if you got a test 2 or 3 years ago when you came to Australia as a student, you can no longer rely on that test if you want to make the 485 application after you complete your studies. The second English change has been the student visa requirement has gone from 5.5, now it's 6 overall for subclass 500 and a PTE equivalent. And that needs to be within the last 2 years if you are applying for a student visa. This is mostly applicable for, in this cohort at least, for people who are trying to make onshore student visa applications. The next is the ending of visa hopping. So we saw there were a lot of individuals who came to Australia on visitor visas and then got enrolled in a college in Australia and applied for their visa. They can't do that anymore. The second one is applicants who are on 485, which is most of you in this webinar, who couldn't get PR before their 2, 3, or 4 years of the 485 expired. There were a lot of you going back onto student visas as a means of extending your stay to figure out a pathway to PR. You can no longer do that either. So please remember, once you finish your studies and you take the 485, you get 2 years and that's it. So be very aware of it. From there onwards, we also have the 485 periods being shortened. Last year, the government took some applicants, depending on your courses, to almost 4 years of TR, even if you did a bachelor's. They've now pared it back to 2 years for bachelor's, 3 years for master's by research, and 3 years for PhD. So if you are on a subclass 500 student visa and you are thinking of making a 485 application, remember, for most of you in this webinar, it will just be 2 years, particularly if you've done a bachelor's or you've done a master's. If you've done only a diploma, it will be 18 months. And unlike earlier, you can't go back onto a student visa, which means if you don't get PR within that 2 years, you will unfortunately have to depart the country or find another visa to go on to. The other changes were that you can no longer get onto a 485 post-study work visa if you're over 35 years at the time of graduation. It used to be 50, so that has drastically impacted a lot of students, particularly those studying master's courses. The next one is reduced allocations. So we have the subclass 189 visa, which is this year, they're only going to grant 16,900 invitations for this financial year for the 189. They've already invited 7,900. So there's only going to be a very few nomination spots left for the rest of this financial year. If you're looking for the subclass 190 and 491, the government has only announced 26,000 spots across the whole of Australia. So it's become very, very competitive these days. From there onwards, student visas. The government has changed the student visa test. It earlier used to be a genuine temporary entrant test where you just needed to prove to the government that you were going to come to Australia, study, and go back home. But now they've changed it to a genuine student test where you need to actually prove that you are a genuine student and you're actually studying to enhance your career prospects before they will grant that. So we're seeing a lot of student visa refusals under this program. So these changes have really impacted a lot of temporary residents in Australia. So let's talk about what the data looks like and how many temporary residents are actually in Australia and how many of you can transition to PR in a given year. So the data, very important in migration that you follow the data. Migration law in Australia, or the migration year in Australia, starts on the 1st of July and ends on the 30th of June every year. Not on the 1st of January and 31st of December, but rather 1st of July and 30th of June. So it's very important to understand these trends so that you can plan for your permanent residency. As you can see for the moment, this is how many visas each state in Australia has received under the subclass 190 and 491 visa programs. As you can see, Victoria, New South Wales, Western Australia continue to have the highest amount of spots with 5,000 between the 190 and 491. South Australia and Tasmania are the next highest. Then you go to ACT, Northern Territory, and Queensland, which is the lowest. So depending on what state you are, you can now understand how many spots are available in this migration calendar year. That is from the 1st of July 2024 to the 30th of June 2025 in order for us to actually get invited for PR. So that's something that is very important for you guys to be aware of as well. The next step of data is to understand how many temporary residents are actually in Australia at the moment. So this data is current as of the 31st of July this year. This is released by the Department of Home Affairs. You can look it up yourself. But basically, there's 1.1 million temporary residents across the whole of Australia. 0.1 million of you guys out there who are basically on these 4 visa subclasses: 408, 485, 500, and 482. Remember, each one of these 1.1 million people are probably looking for PR. Not all, but a majority of these visa holders would most likely want to permanently stay in Australia. So your job is to become one of these 1.1 million people who ultimately gets permanent residency. So let's see how many spots are actually available. So out of the 1.1 million temporary residents there are, Australia is for this year, that is from the 1st of July 2024 to the 30th of June 2025, only going to grant 26,200 new invitations across the subclass 190 and 491, and only 16,900 across the subclass 189. So you can see how many temporary residents are there, and there is only this much left, or this much allocated for the purposes of getting skilled PR. So that's something that you really have to think carefully about, because you really are trying to just get these 50 odd thousand spots that are available, or 40 odd thousand spots that are available from this 1.15 million people. So knowing the big discrepancy between the demand for PR and the supply for PR, let's look at some of the options we have depending on the type of visas we have. So moving on, let's look at pathways to PR depending on what visa you currently hold. The first visa you hold at the moment is subclass 500. So when we look at the subclass 500, we have, if you are currently a student visa holder, you have about 4 different visa types available. So the first visa type available is the subclass. Obviously, you can go for the 485 as well, but here I'm talking about what options you have apart from the 485. So one is, if you're particularly for those applicants who are studying like a master's level course, you can actually look and see whether your bachelor's, particularly if you studied your bachelor's overseas or if you studied it in Australia, you can look and see whether you can actually get a skill assessment. And if you have at least 65 points, you can express an interest. There's a lot of people who tell me, oh, I'm on a student visa, I don't know if I can apply for skill migration. There's no restrictions. You can absolutely apply for it as long as you have a skill assessment and at least 65 points. The next type of visa is another student visa. So particularly, for example, if you are studying a diploma of community services and you can't get a 485 visa, you may think about applying for another student visa and then completing a bachelor's, for example, in order to be eligible for the 485. So there is no restriction. If you are a student visa holder, you can apply for another student visa. The next 2 types of visas available for subclass 500 visa holders is actually employer-sponsored visas. So the 407 is a great option if you are going to be over 35 when you complete your student visa. That's a question I get a lot in a lot of my private consultations, where applicants are currently student visa holders and they are basically going to be over 35. Therefore, they'll be ineligible for the 485. So if you do have an employer that can sponsor you, you don't even need work experience. You can use your educational experience to get that 407. The last option is the 482 visa, or even the 186 in some instances, but it's not many people that qualify for the 186. Most applicants qualify for the 482 visa. So if you have an employer, if you're on a student visa, but you have at least 2 years of work experience from overseas or even in Australia, you can definitely go for the 482 visa. So if you're a student visa holder, there are multiple options. You can start with a 485, or otherwise you can go for any one of these 4 visas. The next step is if you are a 408 holder. This is the cohort of applicants who are on that last COVID visa, as it's colloquially known. If this is one of you, your visas are likely going to expire within the next month to next 6 to 7 months, depending on which 408 visa you got. If you're on this visa, firstly, you can go back onto a student visa. So only the 485 holders were restricted from going back onto a student visa. So that's not a problem. You can definitely go there. The second option for you is also a 407 if you don't meet the 2-year work experience requirement, or if your employer doesn't think you have the skills for you to be earning the minimum salary threshold for a 482, you can go for a 407. The next steps are, obviously, you can go for a 482 as well, which is where you can have your employer sponsor you for a employer-sponsored work visa. These visas can be granted anywhere between 1 and 4 years, and it is very popular these days. But you must be earning at least 73,150 plus super for your employer to sponsor you in this. And the last one, obviously, is if you're on a 408 and you have a skill assessment, or you're eligible for a skill assessment, you can go for the skill migration options as well. For applicants on 485, these are the applicants who are most impacted by the recent changes, particularly those applicants who are on 485s that are expiring in the next 1 to 3 months. You really, really, really need to think about where you go next. You can no longer go for a student visa, which means you can't buy more time and stay in Australia till you find out a pathway to PR. So you are going to have to literally do one of these two options. You're either going to have to apply for skill migration, which is an invitation-based system. That is where you get your skill assessment, you get at least 65 points, you tell the government you're interested in migrating, and then the government decides to invite you. So if you don't get an invitation before your 485 runs out, then it's going to be a bit problematic. It's going to be difficult for you to find another type of visa to go onto. If you don't get an invitation, you can't go back onto a subclass 500 student visa, as I said. So most applicants on 485s these days are actually resorting to an employer-sponsored visa. Apologies. That is where you have an employer who's either willing to sponsor you on a 407 training visa if you have only 1 year of work experience, or if you have 2 years of work experience and your employer is willing to pay you 73,150, you can go for a 482 visa. And lastly, if you have 3 years of full-time work experience, post-qualification, and a skill assessment, and your employer is willing to sponsor you, you can go for a subclass 186 direct entry visa, which is a employer-sponsored PR. Remember, the first two visas, 407 and 482, are not permanent residency visas. They are merely temporary residency visas that allow you to live, work, and train in Australia, whereas the 186 is a direct entry permanent residency permanent residency visa. So if your employer is willing to sponsor you, you can go for that as well. So if you're on a 485 and your 485 is expiring within the next 12 months, I would really, really caution you to think carefully about what your next steps are. Because if you don't get invited for PR, or if you don't have an employer sponsoring you, unfortunately, you may have to depart the country. The last one or last type of visa holder that is present in today's webinar are the 482 holders. Most of you will be fine, particularly if you have a good relationship with your employer and your employer is willing to support you throughout till you get PR. The first obvious thing is, if you're on a 482, you definitely have a skill. Look at the skill, see whether it's on the short-term list or the long-term list, and then use that to obviously get a skill assessment, gather your points, and express an interest. If you have 3 years of full-time work experience while you're on a 482. So for example, if you are still on your first year of your 482, but you have now 3 years of full-time work experience, both with this employer and by combining previous years of experience, you don't need to wait for any time. If your employer is willing to sponsor you, you can go for the subclass 186 direct entry. On the other hand, what you can also do is, if your employer is willing to sponsor you, you can work on your 482 for 2 years, and your employer can sponsor you for the 186 transition stream. This is mostly available for individuals who have skills on the short-term list and therefore are not eligible directly for the 189 visa or the 186 visa. The last option is you can go for a student visa. For example, if your 482 visa is coming to an end and your employer does not want to renew your visa application, they don't want to sponsor you for a 186, if you've been made redundant and you can't find another job, you can also go for a 482 visa. So you can go for a student visa while holding a 482. So those are some options available, or different types of visas you can go for, depending on the visa that you are holding. Planning for permanent residency, and how do you make strategic decisions when it comes to planning for permanent residency? In this, I'm going to cover changing courses, because that's a big question I get all the time. Moving interstate, that's another thing that applicants come to me all the time for. And lastly, how to explore employer-sponsored versus skilled visas. So let's talk about changing courses. When should you consider changing your course? You should consider changing your course if you're not enjoying what you study. But since this webinar is more about PR, let's talk about how to effectively change courses for the purposes of getting PR. If you are currently studying a course that does not lead to a skill assessment on the skilled occupation list, or it is a course that requires 1 year of work experience post-graduation, things like marketing specialist or IT field, software engineering, for example, and you don't really think you will be able to get a job in that field after you complete studying, or you feel like the course that you're studying does not lead to a skill on the skilled occupation list, I would then strongly advise you to consider changing your course to something that you can get a skill assessment in, because that will actually help you apply for permanent residency down the line. So one option is that you can study a parallel course. What does studying a parallel course look like? For example, I'm doing a Master's of Business Administration. I've done a Bachelor's of Commerce in my home country, and I don't have actually any work experience that could get me a skill on the skilled occupation list. I could consider studying a diploma of commercial cookery, or I could consider studying a certificate 3 in carpentry, or another course parallel to the MBA I'm doing, because that other course could be the course that leads me to get a skill assessment. So that's when you study a parallel course. The other option is to completely change your course. So if I am doing a master's or an MBA and I think I can't get my skill assessment using the MBA education, I want to change into early childhood education. So for example, I can then change into a graduate diploma of early childhood education combined with a master's of early childhood education as a package course. That could be another option that I explore as well. So that is an instance in which you change your course without actually impacting your visa. But sometimes you might be doing an MBA or you might be doing a bachelor's and you might say, I don't want to study that anymore. I want to go and do a diploma. Let's say I want to become a painter, house painter. So I'm going to do a certificate 3 in painting trades work together with a diploma of project management, for example. But I got my visa to do a bachelor's. In that instance, you either have to study it parallelly or you have to apply for a new student visa if you want to downgrade your course. There are so many applicants that make the mistake of not enrolling in their principal course, which is either a bachelor's or a master's, and they go and enroll in a diploma level course. Your visa will be you will be in breach of your visa, and it's quite likely that the department will then move to cancel your visa for breaching the conditions. You must always study at or above the level that you were granted a visa for. So if you were granted a visa to do a bachelor's, you must keep doing a bachelor's. You can only change it to do a course that is a lower level if you apply for a new student visa. So I hope that helped you when deciding whether you should be doing your current course or changing your course. Let's go back to skilled migration. Skilled migration has 3 visa subclasses: subclass 189, 190, and 491. The 189 visa is administered by the federal government. The government in Canberra is the ones that invite applicants for the 189, and they have the same rule for all applicants in Australia and overseas. The 190 and 491 visas are administered by the relevant states and territories of Australia, in which there's about 7 or 8. Here, what you need to understand is the different states and territories set their own rules depending on how many state nomination spots they have got from the government. So the government is offering each state at the start of the migration calendar year a number of nomination spots for the 190 and 491. And once they have those spots, they go and set their rules. So if you're living in a state and you think another state is better for you, you really need to think about, you really need to follow some logic before you think about moving interstate. So how would I go about it if I was thinking of moving interstate? Firstly, I will see whether that state has their own skilled occupation list. So there's a big skilled occupation list published by the Department of Home Affairs, and then each state and territory has sub-occupation lists within that. So then the question is, do you have, does those states have their own sub-occupation list, or are they inviting people from any of the, are they inviting people from the state occupation list that the Department of Home Affairs has? So check and see if they have a sub-occupation list, check and see whether your skill is on that list, or if they are willing to invite any applicant as long as you are on the skilled occupation list, check and see whether you have that skill. So that's the first thing I would do. I would see whether that state has my skill, my education, my work experience in demand before I consider moving to that state. Secondly, I'll see if they have a residency requirement. Some states say that you must be living and working in the state for at least 6 months or 3 months or 1 year before you're eligible to express an interest for their 190 or 491 visa programs. So you have to check and see how much visa you have left and whether you have enough time left on your visa to move to that state, meet that residency requirement, and then apply for the expression of interest. The third thing I would see is whether I have time to do a skill assessment. So for example, my visa is expiring in February next year. Some skill assessing bodies could take up to 4 to 6 months to give give an outcome. So the question is, do I have enough time to get that? I would check that. The next thing is I'll check and see whether the state I'm moving to actually has enough nominations. So for example, Queensland, they only have 600 spots for the 190 and 600 spots for the 491. So I'm just going to check and see whether whether there's enough state nomination allocations for me to actually move to those states. Whether they have actually enough allocations for me to move to that state and be competitive in that state. So if I'm moving from, let's say, Western Australia, where they have 5,000 spots, to a state like Queensland that has only 1,200 spots, I am going to really think carefully before I move. The last one is we need to see whether the state requires me to be working in my nominated occupation. So for example, Victoria does not require you to be working in your nominated occupation. You just need to be working in skill level 1, 2, or 3. So if your state requires you to, for example, if you're an accountant, to be working as an accountant, and you really don't know if you can find a job in that state as an accountant, then moving to that state might be a little risky. So before you move states, please carefully think about each one of these things and see whether you can actually meet that and then move to that state. Just because it's a regional state or just because you think, that state is not as competitive as the state you're in, don't just pack up and move. Think carefully and then decide whether you're going to move or not. Now, let's talk about employer-sponsored visas for a minute. So employer-sponsored visas usually have 4 categories broadly. There's a 494 as well. I've not included that in this presentation today, but that's the same as the 186, but it's available for regional employers. So 407, 482, and 186 visas are employer-sponsored visas that are in very, very high demand at the moment. As I said before, 407 is a training visa. It is meant to be an occupation-based training to enhance your skill. So in order to apply for a 407, you must have at least 12 months of work experience in your nominated occupation, at least 12 months of education experience. When it comes to the 482 visa, it comes to you need to have at least 2 years of work experience. The government is intending to reduce this to 1 year at the end of November. But the biggest problem is you must have at least 73,150 plus super as a salary if your employer wants to sponsor you on this. 407 visa does not lead to PR, but 482 visas have a transition scheme where you can be on the 482 for 2 years, and after 2 years, your employer can transition you to the 186, which is the PR visa. The last visa is called the 186. This visa has both the transition arrangement under the 482 and the direct entry arrangement under the 186, which is basically where you need a skill assessment and at least 3 years of work experience, and your occupation must be on the long-term list. This also requires you to have at least $73,000, 150 plus super as salary before your employer can sponsor you. So these are the 3 common and popular employer-sponsored visas, particularly useful for applicants who are either going to be over 35 by the time they graduate, or applicants who are on a 485 and their TR is going to expire in the next 12 months. The last thing I want to talk about today is the skilled visa program. There are 3 options here. That is the 189, 190, and 491. They're very competitive, as I flagged at the start of my presentation. For the 189, there's only about 16,000 spots. And for the 190 and 491, there's only about 26,000 spots combined across the whole of Australia. So if you want to be one of those people, you need to follow these following 5 steps. Step 1, you must get a skill assessment on the skilled occupation list. Step 2, you must gather at least 65 points on the skilled points test table. Step 3, you must get at least, you must express an interest with the federal government for one of these subclasses or a couple of subclasses, depending on eligibility. Step 4 is you must register that interest with the state government if those state governments have a registration of interest process for the 190 and 491 visa. And then you have to wait for an invitation. If you don't receive an invitation, not much you can do. If you do receive an invitation, you can go ahead and apply for one of these options. Right. The last thing we're going to talk about is visa refusals and what we can do about it. Some of you, maybe your bridging visa is associated with applications for student visas, or some of you may be on bridging visas after applying for other temporary visas. Let's look at what you can do in the event that you actually refused. So, as I said before, student visa applications have a very, very high chance of refusal these days because a lot of applicants made onshore student visa applications before 1st of July. The law changed and it restricted you from being able to apply. So what a lot of student visa holders did is they lodged, or what a lot of 485 holders did is they lodged student visas, and often they lodged it at an education level below what they already had. So if you already had a degree or a master's, you may have lodged it on a diploma level. Most of these applicants might be refused because the new test for assessing student visa holders is called the genuine student test. The genuine student test is really looking at whether your application for a student visa was made because you are genuinely looking to study or because you are looking to extend your stay in Australia. How the government assesses this is they first look and see whether the course that you have applied to study is a course above the qualification you already hold or below the qualification you hold. If it's below the qualification you hold, they will carefully scrutinize whether they should actually give you that visa or not. If you are already hold a bachelor's and are now trying to study a master's, you will usually satisfy the first part of that test. But the second thing that the government is going to look at is to see whether you have been in Australia as a temporary resident for a very long time. Usually, if you have been holding a temporary residency visa for more than 5 years, you will typically be considered not a genuine student. The third is to see whether the course that you're studying has a future value to yourself and to Australia. Unlike those days, you don't need to convince the government that you're going to go back to your home country. If the course you're studying has a future value to Australia, you can simply say that to the government and actually tell them why you want to study that. Now, if your application is deemed not genuine and the government refuses it because you didn't have the finances or you didn't satisfy the genuine student test and you are currently in Australia, you may have the option of appealing that refusal to the Administrative Appeals Tribunal. This is true not only for student visa refusals. If you've applied for a 485 and it's refused, if you've applied for a partner visa and if it's refused, if you've applied for a 482 and it's refused, any of the employer-sponsored visas, skilled visas, anything, as long as you applied for that visa in Australia and you are in Australia at the time of refusal, you will have the right to review that refusal. That is through the Administrative Appeals Tribunal, which is about to be changed to the Administrative Review Tribunal. Basically, you pay the application fee, which is about $3,500, and you lodge an application and say, I don't agree with the decision that the case officer made when they decided to refuse my application. The tribunal will then hear your case and they will hear it fresh. They'll look at all of your evidence again and they will decide whether the case officer made the correct decision or not when it came to refusing your visa. Usually you can provide written submission as to why the case officer's decision to refuse your visa was not correct. You can also attend a hearing. Typically, if the submission is not enough, they'll invite you to come to a hearing. And you can also argue with the tribunal member and show to them why the law should be applied in your favor and why the visa should not have been refused in the first instance. So this is something I regularly do for clients. We appear on their behalf. We write written submissions. So if your visa is refused while you're onshore, you can always have it reviewed at the tribunal. And while you're awaiting the decision at the tribunal, you will continue to have your bridging visa A, and you can continue to actually study, express an interest, work, apply for PR while you're on that bridging visa A. There is no restrictions. You can even get a bridging visa B and travel overseas. So a big mistake I see a lot of people do is they apply for the appeal because their visa has been refused, and then they just wait. They don't do anything. But you must actually use the time productively. You must ensure that you do that you get the skill assessment done, that you express your interest after gathering 65 points, or you're talking to your employer about sponsoring you. If you have a spouse who's a permanent resident, you may want to discuss partner visa options. My biggest advice to you is, if you are currently having a visa refuse that you have appealed, don't just wait. Keep pushing to try and get PR. Now, we've got about 5 minutes. Let's wrap this up quickly. Let's look at visa timelines. How long does it actually take to get a visa, a PR rather? Skilled migration. Skilled migration really starts on the day that you become eligible to get a skill assessment. Skill assessment is the most vital thing when it comes to getting permanent residency in Australia, in my view. Once you're eligible for a skill assessment, which you won't know till you actually look and see whether you're eligible for a skill assessment, it may take you about up to 3 to 4 weeks to gather all the documents. You might need service letters from your employer. You might need to look at pay slips, variety of things you need to do. You need to prepare the application, which could take anywhere between 2 to 3, 4 weeks, depending on how complex it is. And then usually a skill assessing body may take anywhere between 8 weeks to up to 6 months, depending on who the body is, to return an outcome. So remember, till you get your skill assessment, you really can't go for the next steps, which is to express your interest, wait for an invitation, and then apply. If you receive an invitation and you apply for a 189, 190, 491 visas, typically it's taking anywhere between 12 to almost 24 months to process these days. But that's not a problem, because you will get a bridging visa after you've applied for your visa. Remember, just expressing an interest does not give you a bridging visa. You must wait for a visa to be granted before you get a bridging visa. Employer-sponsored visa timelines. This is really crucial, particularly for those who are on 485 applications, because if you don't get the timing right, you will be in trouble, particularly because visas like the 482 have advertising requirements where you must advertise the position for at least 4 weeks, which is called the labor market test, and prove that you can't find equally skilled local employees. And only after that will the department allow you to make a nomination application. So at the very least, it will take more than 4 weeks. So you really need to plan it carefully, depending on when your visa is expiring. And also remember, it's a 3-step application. You must do the standard business sponsorship application first, you must then do the nomination application, and the last you can do the visa application. Please think that please note that you can lodge all 3 applications together, but it does take some time and a lot of documents are required. So I hope this was helpful. Thank you so much for joining us, and we will be in touch. And if you guys want our assistance, please do not hesitate to contact us. Thank you all.